So my name is Muriel. I'm a solicitor, and I used to be a banking solicitor, but for the last 3 years, I've worked in the area of assisted decision making. And one of the things about it is, I know when you're in the throes of a situation where you maybe are dealing with things are changing at home for you or for your mom or for your spouse or for somebody in your family, and you're thrown somewhat into crisis mode, then um, it's difficult sometimes to find the time to think ahead or to take advice, or I find sometimes that you're going from one situation, one scenario to another. My reason, I suppose, for moving into this area of law is that this is my husband a few years ago. And when Martin was in his 50s, he was diagnosed with early onset dementia, um, Alzheimer's. So it's an area that, in practical terms, I'm very familiar with. Martin and I lived through, I suppose, all the different steps when you're beginning to wonder what's up, and then you're having tests, and you're getting maybe not great news in terms of an illness showing up on scans, and at the same time you're navigating your life. And I remember one of the doctors said to us when we left St. James's Memory Clinic, which is where we were for about 18 months, um, back and forward getting tests and diagnoses, that now you know the main thing is to go out and enjoy your life and get back to as normal as possible. And that kind of dovetails quite well with my experience of this area of law. So while in some cases, if you're dealing with a situation that you're beginning to think something's up and your life is changing, it kind of dovetails with the fact that the law has changed. So it used to be the case that you maybe made an enduring power of attorney, and if some people didn't have capacity to make decisions, then um, it was a question of black and white. So you had capacity or you didn't. You were able to manage your affairs or you weren't. I'm happy to say that the new Act actually recognises the truth as I guess we know it, which is that it's never like that. It's never 100% black or white, ever, I don't think. Um, because when we talk about capacity and being able to make decisions on your own, I don't know any person who makes all their decisions on their own, because we're not an island. And this new Act, I'm calling it a new Act. I know the screen there says 2015. It was written in 2015, but it actually only came into being in 2023. And the reason for that was that a lot of the practical consequences of it took some time to set up. So that was one of the reasons. So when I studied this new law, I'm going to call it new, that recognized that actually people can have capacity for some things and not others, and that it's graduated approach to somebody who, for example, one of my clients and a lady that I work with is very well able to manage her day-to-day bank account. She has a card, she taps on and off the bus, she has a job, she goes to it. But she herself asked for an assisted decision maker for what she calls her big money. So she was left money as an inheritance and she was unsure how she could manage that money. And to me, that's the beauty of the new Act, is that it recognises that you can have capacity for some things and not for others. And again, I would say that just makes us human, because I have capacity to practice law, but I don't have capacity to, I know, be a doctor or, I can't bake the way my mother bakes. We have different capacities, and that's what I actually love about the Act. Some of the practical sides of it are difficult or complicated, but the idea behind it is that you have the right to make your own decisions for as long as you can and as many as you can. And when you're in a situation that you are not able to make your decisions and you need decision support, then you can choose who that decision supporter is going to be. So, what I've written here is that if you want to make your own decisions about your own life and your own future, then it's worth knowing about this act. It's a law, and it's brought in new rules, but it is worth knowing, at least in broad strokes, what it's about, because who doesn't want to make their own decisions? So, um, the difference in this act, it actually replaces one from the 1880s, which is an old English uh, law called the Ward of Courts Act. So one of the things that is actually going to change and is in the process of changing is that in Ireland from 2026, so next year, it won't be legal to be a ward of court. Wards of court are being processed out of wardship and discharged to a different level of decision support. So it might be a lesser level than they've had before, or it might be greater, depending on what their needs are. But those needs are assessed now, and nobody from 2026 will be a ward of court. I say that, although the courts are slow getting through the application, so it might go on a little bit longer. So the thrust of the act is that it presumes capacity, which means that there would have to be some reason why you would doubt that somebody can't do something before they would be asked to have a decision supporter. And that's not just at the outset. So in some cases, if I'm an assisted decision maker for someone, and you'll see later that's a thing now, I must presume capacity, even though a court may have said a person doesn't have capacity, or a doctor's report has said this person doesn't have capacity for X and Y. But when I approach the person, I must start out from a presumption of capacity, because we have good days and bad days. And because the second principle is that the overriding feature is the person's will and preference. And so as somebody's assisted decision maker, or somebody who is there to support someone else with decisions, it's no longer good enough to do what you think is in their best interests, you know. So I'm not sure if I have it on my slide here, but there is a little GIF that's going around to say my best interests are none of your business. Um, so so the deciding factor and the guideline that we need to follow is, what does that person want? And then if we don't know and we can't work out what that person wants, what would they have wanted? And that's why it's really important that, as far as possible, if somebody is assisting someone else in their decision making, they need to be somebody that knows you. You know, I often, Kim has heard me say before that I think I'm going to have my sister-in-law as my assisted decision maker, because I can't buy a piece of clothes. I can't buy a dress or a skirt without asking her what does she think, because she knows better than I do. She has better style, let's say, than I do. So we all have our go-to people for certain things, and it might be somebody in the family who just is good with money, or is good with DIY, or good with other things. And that's our go-to person for those decisions. Doesn't mean they make the decision for you, but they may be somebody you consult around those decisions. And so the purpose of the Act really is to say to us, now, for your decisions now and in the future, you have the right to choose who you want to be your decision supporter. We may never need decision support in the sense of being the highest level of support. For example, Martin and I had powers of attorney, enduring powers of attorney, and they kick in when you no longer have capacity to sign contracts or manage your bank accounts. But in our case, luckily, Martin and I had a lot of property and bank accounts in our joint names. So when it came to um, needing to make decisions where somebody had to sign for him, in fact, we actually never used it. But it was good to have peace of mind that we did have it there if we ever did need it. So um, I've got off on a bit of a tangent, but basically what we're saying is that if I wanted anyone to be my other decision maker at the time, of course it would have been Martin and vice versa. And so I was his attorney and he was mine. And we never actually needed to use it. But if we had, then I would have been there making decisions with Martin. And these rules still apply. So it's not that I get carte blanche to say, right, today, Martin, you are doing this, or we're moving house, or, you know, the guiding principles in the Act are always to give effect to the other person's will and preference as far as possible. And if you can't work out now what it was, then you go by what the person has said to you previously and what you know they didn't like. Like, it used to drive them mad, this, or well, then we won't do that, you know. So at the core of the new Act is a very high esteem for a person's right to choose. And that if somebody is assisting you with decisions, that it'll be the minimum necessary for what you need. So the test, I suppose, maybe some of us who are on this presentation are familiar with what is called the mini mental. I think it might be called the MMS. So it's a test that I know we had a number of times where a medical professional will ask you questions about who's the president of the day and what day is it, and can you count upwards in sixes and downwards in sevens, or testing ability, I would say, rather than capacity. So this Act changes that. And the assessment is now, they call it functional. It means it has a purpose. It's for a purpose. So when a capacity assessment is carried out for the purpose of having a decision supporter, the assessment is carried out by reference to a number of decisions that need to be made. So it's not made in a vacuum. So for example, if I have, as I do, clients who say to me, we have some decisions to make and my mom's not able, she's really not able to understand that she has money in the bank and she's being offered other money, and she finds it hard to weigh up her choices. And I would like to support her making her choices. And we've spoken as a family. And so when I write to a medical practitioner, maybe a geriatrician, maybe a psychiatrist, then and I'm distracted just thinking it's not just for older people, you know, it may be somebody that's had a sudden stroke or a brain injury or an accident at work or an accident on the road. or it may be a younger person who has an intellectual disability all their lives. But in any event, when the assessment is carried out, it's always carried out with a view to the decisions that need to be made. So when I write to that medical professional, I'll say to them, the situation the person is in at the moment is that they need to make a decision around their accommodation, or they've had an inheritance and there are decisions about how to invest the money or how to use the money or how to spend the money. And as a family, we think it might be a good idea if this person either has a holiday or has a house or any multiple number of things. Then when I ask a medic, a doctor, to decide to carry out an assessment, it will be with reference to that decision. So they're not assessing, I don't mean to be crass about it, but they're not assessing whether the person has high intellect or is able to write an exam. And it's not an exam. I've had people say to me, well, what if my mum doesn't pass? And I said, but she's not going to pass because there's no pass and there's no fail. It's all about, here's a decision. Is that a decision you can make on your own? And if it is, then you have capacity for that decision. And so when I'm asking somebody to carry out an assessment of somebody's capacity, it will always be with a list of questions, a list of decisions that need to be made. And whether that person in this moment is able to make that decision or whether they need support from somebody that they know or from somebody else. So the people who can carry out, that's another thing that it doesn't have to be a doctor who carries out the assessment. And I think this is really, really useful because in the case, for example, I know there's one young lady who is a client of mine and she's in her 20s and she had a brain injury at birth. And so there is a number of she's compromised in a number of ways. Her health is compromised. And her speech is very difficult. So she is largely nonverbal. But she has a speech and language therapist who works with her, and they've devised a system where when the mum asks her about what she wants to wear that day, or maybe what she wants to do for the next 10 minutes or hour, would she like to watch a film? Would she like to listen to music? Does she want some quiet time? Would she like to sit up? Would she prefer to be reclining? Then the mum asks her the questions rapid fire. So she puts them out there, and if she's choosing what to wear, she'll show her a dress, a top, a trousers. And when I'll call her Mary, when Mary sees what she wants, she will raise her eyes. And in that way, she communicates her choices with her mom. So things are never black and white, you know. And sometimes if you have a social worker or an occupational therapist or a public health nurse who is working with you and your family and the person who is in difficulty for making decisions, then they might be the one who is perfectly able to do a capacity assessment and say, this is what this person needs to make their decisions. And these decisions freak them out. If you ask them about that, they close their eyes. They don't want to know. And it takes somebody, and I think that's the thrust of the whole act, is that it's all about working with the person who knows you, first of all, to assess your capacity, and second of all, to assist you with your decisions. So what level of support might you need in your decisions? There are 3 in the Act, and the lowest, which is the one I think that I've referred to, where you need help, getting dressed, as in to make decisions about what to buy or what to wear, or what do you think about this? I reckon we're all pretty much at that level of support, which is communication and relying on other people to steer you or to assist you with your decision making. If you do have a capacity impairment and you have a decision maker at this level, it's an informal agreement. So while you might have an agreement in writing between you that that person is going to assist you in your decisions, it's not one that gets registered anywhere. So it's an informal decision with somebody that you know and trust who will assist you in making your decisions. The next level of support is more formal. And this medium level of support, so there are three, so there's the lowest, the medium level of support does get registered and you will have a written agreement. And at this level, when you have a co-decision maker, somebody who will make decisions with you, at this level of support, you'll have a written agreement. And people like banks or utilities, like your phone company or your electricity company, when you ring, in this case, they'll need to talk to both people. Both people will need to sign. Both people will come to the decision and communicate the decision together. And where I've seen this really being really useful is where I know in the case of one client of mine who was a ward of court, and similarly, he manages his day-to-day money. He has a cousin who he relies upon for making big decisions with him. And so he would have a co-decision agreement with her for a certain number of decisions. And then she'll be his decision-making representative, which is the highest level for other decisions. So when we talk about what level of support, I'm just going to go to this level here, which is when a person lacks capacity and there are decisions to be made, then one of two things can happen. You can have put an enduring power of attorney in place in advance, in which case, if you have an enduring power of attorney made, if and when you run into difficulties and you're not in a position to make decisions, your power of attorney kicks in. The advantage of having a power of attorney is that you get to choose, when you do have capacity, who do you want to be that person? So when it comes to the point that somebody is found to not be able to make their decisions, and there are decisions that have to be made, then either you have a power of attorney made and your attorney can make the decisions for you, or you need to look for a decision-making representative. So this might be the same person. So for example, say in the case with Martin, so when he lacked capacity, we had an enduring power of attorney. And if it had come to making decisions that he needed somebody to sign for him, I could have done that because I was his attorney. If I hadn't been his attorney, still me, it still would have been the same person, but we would have needed to make an application to the circuit court. And then in that scenario, if I make an application to the circuit court, a judge will decide that, yes, I can be his decision maker. Or if there is some conflict of interest or some other reason why I wouldn't be, then there is a panel of professional decision-making representatives. But at the end of the day, it has to go to court. The reason for that is that to take somebody's ability or power to make their own decisions away from them, they either have to do that, we do that ourselves by having a power of attorney in place and deciding who we want to be. But it's such a serious step that it can only happen by having a power of attorney or by a court overseeing that the person who's going to be making decisions for you is a suitable person, is able, loves you if possible, is looking out for you, is looking for your best interests, and is also looking to put in action what your will and preference would have been to the extent possible. The downside of having to go to court for something like this is there's a cost associated with it. And if the person themselves who has capacity difficulties, if they are paying, then usually a court will award in the region of about €3,500, which, you say it quickly, but it's quite a lot of money. It can be more than that. And the other side of it is that it can take time because there's a lot of paperwork to be done. And when you have your paperwork done, then you take your place in the queue in the courts. And usually it takes maybe 4 to 6 weeks from the time you have your paperwork ready to the time that you get a date. So I'm conscious that I don't want to keep talking, and I'm not a multitasker enough to know whether there's any questions in, but Tim, do you want to
Muriel, so a
say?
couple of questions have come in. So the first one is,
Yes.
can a
Yeah.
power of attorney expire?
Yes. So the good news is it doesn't. Um, so because this is a new act that has come in and there's a new system in place. So before you would have gone to your solicitor and the solicitor would draw up the paperwork and they put it in place. And now this body that's on the slide there, the Decision Support Service, is the body overseeing powers of attorney. So how to make a power of attorney has changed a little bit. But the good news is that if you have one and you're happy with it, it stays. And if you never need it, good. And if you need it in 10 years' time, then you can call on it then. If you need it in 20 years' time, it doesn't expire. Now,
And then the person
if
is
you,
also asking if you want to change who your power of attorney is, what's the process for that?
yes, so that was the second bit. It doesn't expire, but you can revoke it entirely at any time. Um, if you want to change who your attorney is, to be honest with you, I don't know whether you can go through, whether you can just change the attorney. You may need to set up go under the new system. What I would say is if anyone is thinking about or is making a power of attorney, there's scope and it's all done with forms. We can talk a little bit more about that. But on the forms, there are a number of choices. So you can say who your attorney is, or you can have two attorneys. And if you have two, you can decide that they must act together or that they can act each on their own account, so that one or other of them can be your attorney, or that they have to act together to be your attorney. And the other thing that you can have is a substitute attorney. So somebody who's lucky enough to have 3 or 4 children could have two of them to be their attorney, or they may not have their children, you can have who you want. But you can have two people who may act together, or if one of them is out of the country, then you might want them to be able to act independently. And then you can have a substitute in case anything happens to your attorney before you, so that if it is set up, all of those are in place for you at the time.
And there's another question. How do you know if your person has enough capacity to get an enduring power of attorney if they're at the medium level of dementia?
So that's where you go back to this and you have an assessment. So if there's a question mark over, I don't know if my mom is now able to make power of attorney, or my brother has a disability from birth and I don't know if he has enough power to ask me to be his attorney. So that's where you get a medical professional, a healthcare professional. And just bear in mind, it doesn't have to be a geriatrician. If there is, it can be your GP,
I'm
if
assuming
you
you'd recommend the person who knows the person the best.
exactly. And that'll depend in each case, because if somebody, say, for example, somebody has a disability from birth and maybe they're in residential care and they have a social worker who's working with them, or a public health nurse, or so any one of those people on that list, including a midwife, I'm not sure why, but anyway, so, or a nurse. So any one of those people can, and I think the speech and language can be really useful because if you're working with a speech and language therapist, then it may be that the person can't communicate, but that doesn't mean they don't have capacity. So how do you know? The bottom line is, I think you may intuitively know yourself. If you feel that the person does have capacity, then check it out. Check it out with the healthcare provider, with your consultant, with your GP, and then they'll be able to do that assessment for you.
Very good. So the next question is, at what age are you allowed to have the power of attorney? Is 18 years old too young?
So no, 18 years old isn't too young. Yeah, you can do it once you're an adult, you can make an enduring power of attorney. Beauty of it is that it sits there and you may never need it, but having it means that should anything happen, and I think when there's a diagnosis of progressive illness, um, and there is the possibility that capacity might be less, then it's a great time to think about um, what you want, who you want. Nobody wants somebody they didn't ever want. You don't want the bossy sister, in the family like me, to be the one. Um,
Although
so
she'd fight for you.
maybe more than you want, so it's the good thing is that it's your choice, when it's the decision making representative and you have to make a court application, which you can do on your own, but the paperwork, it's just long, but it doesn't mean that you can't do it. You definitely can do it. So, and I've worked with people who have made their own applications and done them really well, for family members. So you can do it, but what I feel as well is that this morning I saw a lady who is 90. She didn't look 90. She's very sprightly and she was in very good humor and she was smiling. But her daughters are making an application to be her decision makers. Yes, and when I go into a room, so I go into where she is in her nursing home or in her home, and when you say to somebody, hi, I'm Muriel, I'm a solicitor, they go from happy and smiling to having eyes like moons to say, what is she? Is she? I remember one gentleman, I'll say his name was Tim, and going into his room, and I met him on his own, and then I met him with his brother, and I was explaining to him that I'm a solicitor, and he was like, "Oh, what did I do?" So that's the downside of the decision-making representative. If you don't have a power of attorney and you have to do a decision-making representation application to court, it brings in court. Who wants to go to court? And then if
Yeah.
somebody is already having difficulties and might be disorientated, finding themselves in a court, even if it's on a Zoom link to a court, it's very, I find it intimidating.
It can
I
be very
go to court.
upsetting.
Yeah,
Yeah.
I go to court for my job and I'm still checking before I go in that I have my ducks in a row because it's just, I'm going to say it's not a nice environment. It's not a horrible
Well,
environment.
it's very serious. So it's
It's
not something you do
very
lightly.
serious. And for a lot of people, they only ever had to go to court or have a solicitor when there were problems. And I feel it is a pity, that people at a stage of their life that they just want to be happy and be looked after, maybe, or, that they can't just say, this is who I want. It has to go through that court process. And that's why I really, really do encourage people to get involved with, so that, sorry, this is just slow to go. Yeah. That decision support service, they have all the forms. They have a
Yeah.
website. Some people may find that they go to their solicitor and the solicitor will say, oh, it's all new and I don't know anything about it. And in a way, that's where we started out here. When you're dealing with a stressful situation in your family, or whether it's your family in your home or a sibling, when you're dealing with a stressful situation, you want to turn to the professionals and that they can say to you, you don't worry about that, I'll do that. Unfortunately, because the Act came in 2023, in fact, you're going to find that your solicitor is going to be saying to you, it's all new. So it's
I didn't
new
know
to
anything about this
everybody.
either.
Yeah. And I've even had I've even had the experience that sometimes the judges will say it's new, and I know I was in court last year or earlier this year at some stage, and we asked for something. So there was a solicitor for the family, and then the person themselves had a solicitor. Like, it's all money, but anyway, and we asked for certain orders, and the judge turned to the barrister and said, can I do that? And everyone else in the room said, yes, judge, you can do that. And he said, okay, this is new. And so if you find it
So people are
difficult,
still figuring it out.
yes, if you find it difficult when you go online, you're not on your own in that. All the medical professionals, it's new to them. All the legal professionals, it's new to them. One of the difficulties about making a power of attorney is that if I'm your solicitor, I can't do it for you on my computer. Sounds like a silly thing, but it's a problem because normally if I'm selling a house for you, I have documents that I use. I use that one and tailor it. If I'm making a power of attorney for you, we need to do it on your computer. So,
Mm.
for example, I had a lady came to see me and her daughter made an appointment. It took us an hour and a half to set it up. That was before we signed it or had a medical report or anything. So she didn't have any diagnosis or any illness. She was just doing it because she wanted to. She had a large family of daughters, but it took us an hour and a half to put the information. She brought her laptop, so we did it on her laptop to bring all the information together and put it up. So all I'm saying about that really is that you need to really find a moment when you're not stressed. You're not going to do it in between doing other things. You'll give up. Sorry, maybe you
And
won't because
do the forums save where you're at? Can you go back to them, or do you need to be able to do the whole thing in one sitting?
yes, no. So it will save as you go along, and you have that option. So it's an interface. It's not actually a form that you can't print it out and fill it in. Um, so they want you to do it online, as if you were doing a revenue form. So if you are doing that, I would say save it as you go and keep saving it so you don't lose
Yeah,
the information. So yes, you can come
exactly.
back to it.
Okay, very good.
Yeah, but the
Um,
website is this one here, Decision Support Service.
so another question has come in. Um, and basically, if you can walk us through very high level the steps to do a co-decision making agreement,
Okay.
which is the
Well,
medium level of support.
yes, and that one is the easiest one, and it's the easiest
Okay.
one to do. So again, you'll get forms from this website, the Decision Support Service. They have template forms. Um, but at the end of the day, what goes into those forms is very much up to the person who wants the support and you, So the two people together as they will go forward. So they make the agreement together. So they agree, you know, in what level, sorry, not what level, but what areas do I need support? And one of the slides that I didn't look at was that the Act separates personal welfare and property and finance. So you might have somebody to help you with decisions around what healthcare supports you need, but your bank accounts are fine. That's all managing itself, or you manage it, or vice versa. You might just need somebody, but you can set out clearly some things in personal welfare and some things in finance, what I need help with. And then that agreement gets registered with the decision support service. And then it's binding on banks, which is great because banks can be the hardest ones to deal with. Now, over the last year, I've had a lot of dealings with banks where I have gone with court orders, either with the person or on behalf of the person. And you need to go with your patients really, because it's new to them too. And they're setting up systems and they're getting better, you know. But it can be, it's such a pity because the idea is it was to reduce stress and reduce problems, but because it's new, I'm finding that it's difficult enough dealing with the banks, because I think in general the banks don't want you in the bank. And when you do go,
Certainly
then
don't want you to change anything without filling in a million
yes,
forms. Sorry to
yeah.
any bank
So
people on the line.
so that's the process. Really, you decide what are the parameters of the decisions that the person is going to support. And then the template is on the website and it gets registered with them then when it's done. And the good thing about that is that when, the banks or the utility companies or anyone say, oh, I have to talk to the person, now they'll be able to talk to both of you.
Yeah,
Yeah.
very good.
I would say
So we
that
have it. Yeah, go
most
ahead.
couples do that for each other anyway, without the written agreement. Well, it's a marriage, so anyway, yeah.
Exactly. So we've got a couple more questions that have come in. So this one is two parts. So is a power of attorney recognized in the Act? I.e., if someone is a power of attorney, are they automatically seen to be the decision-making representative, have the highest level of decision-making capability, or is there an instance where the power of attorney would not be enough authority under the Act?
So under the Act, it's a really good question, actually. So the two are really on a par, but the Act, I wonder would I be able to get up the Act here? The Act is split into a number of parts. And if you actually read the Act, there is, I forget what's in the beginning, but there's a section on assisted decision making. Then there's a section on a co-decision maker and all the rules about that. And then there's a section on decision making representative. And then there's a section on power of attorney.
So if
So,
people just Google the Act, they can actually see the specifics in the Act.
yes, and this decision support service website is quite good for information. But what I would say is that the level, they're on a par, a decision making representative and an attorney. There's very little difference. What I would say is that when it comes to making medical decisions, a decision making representative cannot refuse end of life care. And I believe the attorney would be in a similar situation. So the Act envisages, so the fifth part of the Act is future healthcare, advanced healthcare directives. So briefly, an advanced healthcare directive is where I mean, we all should have one, of course, but if I did have a diagnosis of something of a dementia or some other progressive illness, I think I would very definitely make an advanced healthcare directive, because it's literally you write down what kind of care you think that you would want and what care you feel you
Would
wouldn't
not
want.
want.
Now, it's really useful because when it comes to um, being at end of life stage with a family member, it's really, really comforting for a family being asked to make a decision about end of life care. You know, it's really comforting to know that the person did or didn't want that treatment. You know, if you've put it there, you know, sometimes people say, it can be really granular. I want antibiotics, I want this, but I don't want that. And some people will say, if I have to move out of my house to have intravenous antibiotics, I don't want to go if I'm going anyway, you know. So anyway, you can put down in your advanced healthcare directive all the treatments you want and all the treatments you think you don't want. At the time, you can change your mind. If you still have capacity and it comes to the point of making that choice, it won't override your present choice. And if you choose something that in your advanced healthcare directive you said, I'll never want that, and then the moment comes and you say, yeah, I really want that, then you can totally do that and it overrides your advanced healthcare. But
Mm.
it can be useful to spend some time thinking about it. And I feel I've seen it be really comforting to families because sometimes families feel they need to do the best for their mum or their sibling and they want to pull out all the stops. And then if you can say, look, they wanted this, but they didn't want, you know,
Yeah.
this other treatment, it can be a comfort to the families to know that in a way it's the same thing. You're continuing to make your own decisions into the future.
Yeah. Exactly. No, that's true, and I'm sure it just takes the stress out of the situation a bit.
Hmm.
So we have another question here. Is there a concern that a person is lacking capacity, but that person is not willing to engage in a functional assessment? How can the
Yes.
family proceed in this manner?
Yes. And um it's interesting because um I think if the person refuses point blank and they're not doing it, then that's their will and preference, you know. So nobody's going to do it against their will. What I would say is making, for example, a power of attorney is not for somebody who has a diagnosis of an illness only. It's for all of
It's for
us, you know.
everybody. Exactly.
So when you get into the car, unfortunately, we don't know that we're going to get out of the car because I can't tell you the number of accidents I've seen on the M50 in the last week. You know, when the
Yeah.
rain comes, the accidents happen. So sometimes we know in a year's time, I'm going to have less capacity than I have now. Sometimes we don't know. Uh, but we all can make an enduring power of attorney. So what I would suggest is you can talk about future planning in a way that is more general. So for
So not
example,
just what do you want, but this is what I want. What do you think about that?
yes, I think we should think about having a power of attorney, you know, and both make one.
Yeah.
Um, I have a friend who's a solicitor, and we're threatening to have a power of attorney party where we all do our powers of attorney together.
That sounds
So
fun, although you can't drink alcohol probably and do it.
no, you'd have to, because that would affect your capacity. But I think if you can escalate it back, you know, I think sometimes people get into a situation where we have to do it. And, you know, if you bring it back and say, you know, do we need to revisit our wills? Do we need to think about, you know, God, all the kids have moved out and now we have the house and what would we want to happen here and what do we think? And so in that picture, you can say, you know, oh, you know, I was down with the GP and he said I should make a power of attorney. I never thought about that. What about? So kind of scale it back a little bit and normalize it because actually it should be normal,
It
you
should
know,
be normalized.
because it
So
just
that's
gives
good.
us
So it's
the
not just for
power.
the
Yeah.
person that you think might need it, it should be for everybody.
Because we all might need it and the person who might need it might need it in the future,
Yeah.
you know. So, you know, and if somebody's saying, well, I'm not doing that, it's a bit like making a will. Somebody said, I'm not making a will because then I'll die, you know, which In fact, we're
Doesn't
all
work like
going to
that.
die, you know, so it's good to the 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 thing about it is the choice is yours, and this is giving you the choice to choose who you want to make your decisions, if it was the case that you couldn't.
Very good. So somebody's just asking again, how come it has to be on the client's computer, not the solicitor's? I'm assuming that's to prove that it was the client's wishes.
No, it's the way the decision support service is set up. So to go online and to create your power of attorney, you have a unique ID. And even that can be a little bit difficult. It might be my Gov ID, or it might be they, validate that you are who you say you are. And it's created on your account on the decision support service. So it's a little bit like, see, if you're doing revenue for somebody, they can give you authority to get into their revenue accounts, but you can't get into the decision support service account. It's just how it works.
Yeah, so it's only the person. But
Yeah.
the solicitor can be in the same room and next to the person
Yes.
helping. Yeah.
Yes. And some of the questions that come up, can be a little bit legal, as you're going through them, they would say, what does that mean? So it's very useful if your solicitor will do that. But it is time consuming. Yeah.
Yeah, I can imagine. Somebody is asking, is there any financial assistance for families that might not be able to afford these fees?
So there is legal aid. So sorry, I was about to say something else, but so a person who um the person who's looking for a decision making representative, bear in mind that the person in that case, you will have a report that says they lack capacity. That person is entitled to legal aid in the proceedings. So they might have a separate
Okay.
solicitor. But if you are making an application for your son or your daughter or your husband or your mother, then you can apply for legal aid, but you mightn't get it. So then another alternative is that you can do it yourself. Like it's set up in a way that you can do it yourself, but the papers are long. That's the main thing I would say.
Yeah.
And not always obvious on so if you can Google the court forms, they're literally they're called 55A, 55B, 55C. So they're all 55, court forms 55. You can look it up. Those you can print out and fill in and bring. And the judges are very, very friendly to applicants who bring their own applications. You may end up having to go a couple of times, because something mightn't be right or in the right format. So you can do it yourself. There is legal aid if you come within the legal aid thresholds. Um, and that's, I think, it. Yeah.
Very good. So here I have a very specific question. So this person's Scottish father is registered in Scotland with a power of attorney, with the Office of the Public Guardian. He's now moved to Ireland. They're being told that under the Hague Convention that the power of attorney would be recognized in Ireland. Is that also your understanding, Muriel?
Yes. Yes. And I've done it recently for somebody. So, um, yes. And, even if it wasn't in The Hague, so the US is not in The Hague, but I had a power of attorney recently that was a US power of attorney. And I've got an opinion, a foreign opinion. If you have a power of attorney in another country, then it should stand. Yeah, it should be valid. Yes. And Scotland specifically, yes. So the other interesting thing is that an attorney under a power of attorney is able to make an application. So there are people who are entitled to make applications and other people who have to look for consent. If you're an attorney, you can automatically make an application to be decision-making representative, but you shouldn't need to.
So this person, the next one is kind of iterating, repeating what you said, that a lot of solicitors seem to not know what they need to do. So they approached 18 solicitors, only two of them could do the power of attorney. And they both charged 500. that they think that's quite costly considering they might change it in the future. So that's
Um,
kind of, it's more of a comment than a question, but it seems to underline
yes.
what you were saying.
Yeah, I mean, I suppose what I'm saying is just an explanation of it. It used to be that solicitors would do an enduring power of attorney for, in general, when they're making wills, maybe they might just automatically do an enduring power of attorney with somebody, or if somebody had a diagnosis of an illness or a progressive illness. Um, but now it's so cumbersome to do it. And I think as well, solicitors feel it's kind of out of your control because it's on somebody else's computer. It's kind of you can print out the documents then and sign them and scan them in. So I know that not a lot of solicitors are doing it. Partly it's because it's new, and partly it's um, solicitors don't like when you show up with your paperwork done. They like to have to do it.
They just trust what they know, what they've done themselves.
Yes, yes, so the DSS, the Decision Support Service, do have a list of solicitors apparently that will do your power of attorney. And I'm happy for you to share my information. But um, it is the case that a lot of solicitors are not doing it, finding it very difficult. Yeah.
Yeah. So do you have time for another question?
Yeah.
Perfect. I didn't know if you had a hard stop. So this person is asking, what power does next of kin have under the new act?
Yeah. So next of kin, in legal terms, is next of kin actually never had legal standing. So next of kin is something very useful that the HSE really used for a long time and still use, because in situations where I have clients where they have DMRs or I'm their DMR, like a nursing home will still ask, and who's the next of kin. So I find it useful from the point of view that next of kin are family, and family are always family. But legally they don't have standing. And I think it's recognition that nobody can make a decision for another person, you know,
Yeah.
without that person asking them to, or if the person no longer can ask them to, either has said they want you to by giving you a power of attorney, or by going to a court and outlining the situation and saying she would have wanted it to be me, and all of that, fill out all the forms and have a court say, yes, you can make decisions. So next of kin, I think, is going to have less and less standing.
Yeah,
Yeah.
exactly. So one last question. Is it enough to make an advanced healthcare directive and nominate a co-decision maker or representative in the document?
Um, no, no. So an assisted decision maker, yes, because that's the informal one, the first one, the lowest level of support. But as soon as you need a co-decision maker who you want that it will be legally binding when you both sign together, that has to be registered with the Decision Support Service, which is also the DSS, the Decision Support Service. Um, and they're separate things because a third party can't ever, for example, refuse end of life care, for example. So that to have that, you would need that in your advanced healthcare directive. What I would say is, if all of this is just too much and that's what you want to do, just have that one document. It's persuasive evidence of your will and preference now, you
Yeah.
know, and a court will look at that, you
Yeah.
know. If somebody applies to be decision representative and the whole family say he hated him and he never wanted him, that is kind of, persuasive proof. So if it's a case of writing it down in that form rather than not writing it down at all, I would say go for it. But you won't have banks accepting that for signing.
Yeah, exactly. Um, so I think we've hit all the questions, which is fantastic, and we're just 1 minute over. So I really want to thank you again, Muriel, for taking the time to talk to everybody today, because I think it is a topic that needs more discussion and more just practical information that you are, the expert in.
Oh, well, thank you for saying that. But no, if it can be of help, I think just to demystify it, and I think it just is so important that we do our EP, our enduring powers of attorney. But listen, I want to say thank you for everyone who's given their time to be here today. Thank you. So it's been a pleasure.
Yeah. And just so that everybody knows, we have recorded this session, so we'll do a quick edit of it and have it up on our YouTube channel, I'd say within the week, so that you can share it with anybody else who might be interested. And thanks again, everybody, for coming and for your interest and for all the great questions.